Office's introduction to licensing webinar today. We're going to spend around 30 minutes or so going through a few different areas of specific and general licensing that we hope you'll find really useful. I'm going to cover things like how you can apply for a license, how you can use general licenses that Office puts on our website, and also some tips and tricks for how to make your application go as smoothly as possible. So to introduce myself first, I'm Amy Lambley. I'm the Head of Licensing at Office, and I'm going to be going through a few of these areas, and then I've got a couple of colleagues joining to cover things as well, and so they'll introduce themselves when we present. So this webinar today is designed to supplement previous Office webinars, such as the one in October, where we covered more like a little introduction to licensing. So a little bit at the start might duplicate some of what you've heard before, but we're really going to be going into a lot more detail today. So even if you've had a little bit of this before, hopefully there'll be lots of new stuff in here as well. So what is licensing? A license is something that Treasury or Office can issue to allow activity which would otherwise be prohibited to take place. And this is where that activity would be prohibited by UK financial sanctions. And really important thing, licenses can never be retrospective. So if any part of the transaction or activity has already taken place, then that part would need to be considered by Office's enforcement team and should be reported to them, or we would refer it to them if we become aware of it. But a license allows something to take place in the future, which otherwise wouldn't be allowed. Office is the competent authority for UK financial sanctions. So that means that in order for us to issue a license, there needs to be a UK designated person or entity, or a person or entity which is controlled by a UK designated person. And there also has to be a UK nexus from another part of the transaction as well, who's obliged to comply with UK financial sanctions, and that would usually be the applicant in these cases, for example, a UK registered company or a British national. And so a specific licence can only be granted where there's an applicable derogation. Derogation is quite a technical word, but basically it means a permission or a reason to grant a licence. And this bit's really, really important because Parliament has put these restrictions in place for a reason, and we're only able to undo those restrictions for a specific transaction where we know that there's a good reason to do that, and that's why we look to the derogations. So these can always be found in the relevant legislation. It's very transparent, so if you look at the schedule, you can see the types of derogations that are available. But I'm just going to give a quick overview of some of the most common ones that we see. And you'll know as well that on the application form, there's a box where you need to fill in which derogation you're applying under. So basic needs is a common one that we see. So as the name suggests, this can be things like food, utilities, medicines, and it can also include any dependents of a designated person as well. And it doesn't just apply to people, it can apply to companies. So a basic thing for the company might be to have premises so that it can operate, and that could be licensed under this derogation. For legal fees, that's another really common derogation that we see. We always have to carry out a reasonableness assessment, so we can only ever license legal fees where we consider them to be reasonable. This can feel quite detailed when the caseworker is asking you for information, but it's because the legislation states that it has to be reasonable. So you might see us asking for things like the different fee earners on a case, the different hours that we spent by them, the split between the more senior and the more junior fee earners. We're not just asking those things for fun, it really is important for our assessment and for us to be able to progress your application that you provide them. So thanks in advance for your help with that. Worth saying that you don't need an Office licence to actually provide the legal services, but you do need a licence when it comes to receiving that payment. Another common derogation that we often look at is prior obligations. So this is where an agreement has been entered into with a designated person before they were designated. And so it's really important with this one to set out what that agreement was and to provide evidence of it so that we can see that it was a legitimate agreement from before the designation. So we also look a lot at routine holding and maintenance of funds and assets. So this could be things like payments of fees or service charges to maintain those assets, because ultimately asset freezes mean that we want to be protecting those assets and making sure that they're not dwindled down. So we need to be able to have the maintenance of them. And it's integral, therefore, that we look at not having impairment of those assets. And also sometimes we need to look at things like the health and safety of the public. If you were thinking of something like a building, if it starts to become derelict, and that can pose broader problems. So we'll think about that as well in our cases. We have a humanitarian delegation, which is kind of as you might expect from the name. And then we also have a couple extraordinary expenses and extraordinary situations. For extraordinary situations in particular, I would say that really is looking at the dictionary definition of extraordinary. And as our guidance sets out, it's for situations that are unexpected, unavoidable, and not recurring. It's quite a high bar for us to license under this. So if you're struggling to find another derogation, just ticking extraordinary situations isn't necessarily going to help as a kind of catch-all. It's actually something where you'll need to explain how that three-part test is met for us to issue a license there. The licenses should be specific and include the full payment route, or the full transaction details, and all the parties to that. Again, that's because we need to be able to see that flow and see where the UK nexus is and balance any risks. And something that's really important to say, if you get all that way through and you're issued with a specific license, it still doesn't compel any other activities to undertake, any other parties to undertake activities that they otherwise wouldn't want to do. So if your financial institution has a commercial risk appetite, that means they're not comfortable with a transaction, or there's just other practical reasons or other financial crime concerns, even with an OFSI license, that just permits them to do it if they want to, but it still doesn't compel that activity.
Hi everyone, my name is Louis and I'll be giving a short overview of OFSI's general licenses today. So what are general licenses? To summarise, a general licence allows multiple parties to undertake activities which would otherwise be prohibited without the need for a specific licence. And issuing general licenses is a Treasury licensing power under Section 15 of the Sanctions and Anti-Money Laundering Act, which provides licenses may be general as well as specific. General licenses are unique in that they are not limited to the licensing derogations set out in the UK's autonomous sanctions regulations. OFSI have powers to amend, suspend, or revoke general licenses at any time, but we do aim to engage with relevant stakeholders before taking such action. So now we'll move on to how and why general licenses are issued. So it's important to note that OFSI does not accept applications for general licenses. Instead, they are issued under such conditions as HM Treasury deem appropriate, often in consultation with the FCDO, and who will usually be considered in response to unforeseen circumstances where it has been decided that issuing a general license will best support the government's policy priorities. To give some examples, OFSI has issued general licenses to assist in the implementation of new sanctions measures like the oil price cap or the trust services sanctions, allow for the winding down of relationships when new designations are made, like the Russian and Belarusian banks, permit the continuation of UK businesses or large-scale global insolvencies to proceed, where they involve a considerable number of transactions, address common specific license applications we receive for routine payments, for example, the legal services, gas and electricity, water and sewage general licenses, among many others, and also align the UK's interests with foreign partners. Finally, I'll now cover how people can interpret or use general licenses. So all general licenses are published on the OFSI website, where they can be viewed by everyone, and they're also accompanied by a publication notice, which sets out the details of the license and explains any changes which have been made to it since its issuance. Certain general licenses, for example the legal services or prior obligations general licenses, can also be accompanied by a blog on the OFSI website. These blogs offer further information and attempt to provide answers to any queries that may arise following their issuance. Each general license will include specific conditions which must be complied with for the license to be applicable. Among these conditions are requirements of record keeping, prior notification of use, or reporting. It's worth noting that prior notification is an administrative exercise only, whereby users only have to provide OFSI with their contact information once. And finally, please note that it's responsibility of any party using a general license to ensure that the activities they undertake fall within the terms of the licence. And if you're in any doubt, independent legal advice should be sought.
So I spoke a bit earlier about derogations and the assessments we make for specific licences, but even if a derogation applies, sometimes Ofsted will use our own discretion to still refuse to licence particular activities, and we'll do this where we're concerned that allowing the activity would undermine the purpose or the effectiveness of that financial sanctions regime. So we want to kind of give as much information about this as possible. So to help applicants and to help with that transparency around our decision making, we recently published policy principles which relate to designated individuals, and these are available on our website. So today I just wanted to talk a bit about how we're going to apply these principles and what they mean for you as an applicant, but really I would direct you to the website to have a read through them, and there's a blog that accompanies them as well, explaining a bit more, because I'm not going to go through all of the principles in this webinar today. So the principles are there to help clarify Ofsted's interpretation and applicability of the various licensing grounds in relation to designated persons, and we do hope that they'll help you to understand better the circumstances under which we may refuse to license certain activities, even if it appears that a derogation exists. So applicants would be expected to consider those principles carefully before you apply for a licence, and something that we're asking you to do is to actually make reference to them in your application forms. So if you believe that your application adheres to the principles, then you can set that out, and that will help our caseworkers to square that up more easily. And equally, if you think that licensing the activity may pose issues with the principles, I really would encourage you to be upfront about that as well, and to set it out, but to explain why you think Ofsted should deviate from the principles, because again, that will just help us in assessing the reasons that you've put forward, so we can understand the specific circumstances for you or your clients. And in general, though, I would say we are unlikely to allow licences which deviate from these principles. They don't replace legislation or any of Ofsted's guidance around licences more generally, but as I say, we're really hoping to put more things out to help you applicants with the way you interact with Ofsted. So our caseworkers and decision makers will be applying these to ensure consistency and fairness for our licensing decision making. They're not absolute, so they guide our decision making, but we still very much would say that every case is treated on a case-by-case basis, and so there may be times when we do depart from the principles, but that will just be in exceptional circumstances. The principles are listed in general hierarchical order, with the first principle taking precedence over the second and so on, and there's 16 principles in total. The first two principles I will specifically mention because I think they're really very important. The first outlines that Ofsted retains the discretion to refuse to license applications where we determine that even where the licensing purposes have been satisfied, it's not appropriate to license that activity. And the second principle says that we won't license activity where it could undermine the integrity and objectives of the sanctions regime, which will be the regime under which you're applying, depending on where the designated person is listed. And we won't allow that if it undermines it either in terms of the nature of the activity or the value of what would be licensed. I've covered a bit around the policies and how we approach the actual decision making for specific licensing. I want to outline our more general approach and our process for what we do when we receive your application and how we take that through. So stage one is the initial assessment of the application, and here we're looking at whether it's a new application or whether it's an amendment and checking the correct process has been followed accordingly. We'll be triaging the application, so we'll be prioritising it according to any urgency or genuine evidenced need for prioritisation. This could be something like humanitarian purposes or a risk to life. I would encourage you to include any hard deadlines that you're working to in the licence application, because we do take that into account with triage, but the onus is still on you to make sure you apply in really good time and not to send in an application with a hard deadline that we won't be able to meet through our process. Our team then manually review every application to check that it meets the right quality in terms of the essential information that we require. If it's incomplete, we'll return that to you with an explanation of what we consider is missing, and we'll talk a bit more in a moment about incomplete applications as well. If all the information is there that we need, or at least to make an initial assessment, it will then be allocated to an experienced caseworker and they'll set about their comprehensive review. So that brings us on to stage 2, which is around gathering information. So the caseworker will be looking at which delegation you've applied under, who the parties are, who the designated person is, and the timescales for the activity. And they may come back to you, and sometimes this can happen a few different times, to ask for supplementary information. So please do make sure that you're monitoring and responding to any request for information promptly. And how many times we have to go back will depend on a huge number of factors: how complex the transaction is, the quality of information that you've given us, and also it can vary depending on the purpose that you've applied under. When the caseworker considers that they've got all the information they need to make their recommendation on if a licence should be granted, then they will draw up that recommendation, take account of any necessary legal advice and other cases and our relevant guidance. And then it will go to a decision maker in line with Ofsey's delegation framework, and that's published on our website as well. Who makes the decision will depend on a number of factors. It is possible at this stage that we may come back to request additional information as well if the decision maker asks for something which we hadn't already gathered from you. That doesn't always happen, but it's possible, so do still continue to kind of monitor your inbox and look for any requests. And then when the decision maker has taken their decision, we'll notify you of that as quickly as we can. So if it's a rejection or a partial rejection where we're not allowing exactly what you asked for, we'll give you reasons for that decision, and we'll also outline any next steps of what you can do if you want to challenge that. If we've decided that we will issue you with a licence, then the caseworker will provide a draft copy of that to you. Important to note at this stage, that draft copy, it's just for you to check for factual accuracy. It's not an opportunity for you to add added extras in that weren't covered in the previous application. The decision's already been made. If there's anything additional that's needed here, then it needs to be through a new amendment application. But this is really to let us know if there's a spelling, an incorrect address, anything like that that needs to be changed on the draft licence. That will then be finalised and issued out to you by email. You can share that with relevant parties, so the licence will include everybody who's party to the transaction will be named in it. So if you're, for example, a law firm, you can share that with a financial institution as necessary. So one licence will cover the whole transaction that's detailed in it. And as well, that's part of the reason why the licence has to be so specific in explaining what is and isn't covered, because it does then allow for all parties to carry out that activity. And the final thing I'll mention on this is all of our cases are now actively being progressed. Now our caseload is at a manageable level.
So what we expect from applicants when it comes to amendments, we've now introduced a new policy, which is we expect if you have any amendments, variations or extension to a license that you would like to request for, then you will submit that to Ofsey via email, a new email chain for that change request. And you need to ensure that you've completed a full application form to send in that email chain, and also make sure the original license case reference is clear in the body of the email subject. If you have multiple amendments to the single license, then please do group these together in the same email, so then all those requests can be done on that license. Why we've introduced this change, initially we found it difficult to locate the correct case and ensure it was assigned to a caseworker. So please do not assume that if you're sending a request to the original person who dealt with your license the first time, that this will be the same person who will deal with your request. If once you send that in, we will assign it to a new caseworker. You may receive the original person who works on your case. It also helps us with MI, moving in and streamlining our MI to just make sure that we're able to see the difference with new cases we're receiving and then those that are requesting for amendments to original license. So this will help us to capture this information, and we'll be able to publish this in our annual reviews as well. This is just a temporary arrangement until we work through the development of our new online forms for applications and reporting, which applicants will access on the office website and complete online. How it benefits applicants: it avoids delays in processing your application. If you have an old case, it will reopen if you send a request on that old chain, and that could mean that we may overlook this, and so there's a delay in the processing time. It's also a clear distinction between your previous license and the changes you would like to make going forward. And then also the new email request will not be missed. So again, affecting the processing time.
So I just mentioned the new process update, which is return without action, and I wanted to go into just a little bit more detail about what this means for you as an applicant. So this is a fairly recent process which we've introduced, and there's information about it on our website as well, where it's really to allow OFC to focus on applications which are ready to be progressed, where a license is needed, rather than any speculative applications or applications where we're really nowhere near having the information that we need to make a decision. So how are we defining incomplete applications? This is where key information is missing. So that could be an explanation of who the designated person is, why a licensing derogation applies, what the UK nexus is, and what the payment route is, things like this. So the really, really crucial information. We totally understand that as we go through assessing the application, we'll need to ask for further information. So it's not necessary for your first application to include everything, but it does need to include this key information so that we can continue progressing it. If we send you back a return of our action explaining that we've not been able to take the application forward, we will provide clear information about what was missing, and then you just need to reapply with that full information. But your new application will be treated with the same level of priority that it would have been in the first instance had all the information been included. So we recommend really taking your time over the application form, making sure everything you need is there, and then we'll be able to crack on